Hello, my dear brothers and sisters. Today I have come before you with a very interesting topic, namely the offense of misappropriation, criminal breach of trust, and cheating. First of all, I'm excited to talk to you on legal point. The offense of misappropriation and criminal breach of trust are not continuing offenses. Law is a science. When it is presented, it is an art. So let us know why it is not a continuing offense. In support of this argument, I will press into service the law of the land and one citation of the apex court. Criminal Procedure Code 1973, Section 472 reads, I'll reproduce the same. In the case of a continuing offense, a fresh period of limitation shall begin to run at every moment of the time during which the offense continues. This is given in CRP Section 472. Now I got, in support of this, I got citation that is based on this only. A 1961 Allahabad 88. Tilok versus C&C Vastava and others opposite party. Para number 4 and 5, pages 88 and 89. A continuing offense means an offense that continues. The word continuing being used as an intransitive verb. Continuous means to remain in existence or into present condition, to last, endure, persist in being. Another meaning of it is to remain stayed. Now this meaning is given in Murray's dictionary. These meanings show that the act amounting to an offense must be a continuous act in order to make the offense a continuing offense. It must be an act that remains in existence or in its present condition. It exists from moment to moment. It must be an act that lasts or endures for a certain period. Continuing means continuous. Why I clarify this legal position? The reason is, if somebody has done some offense for breach of criminal trust in year 2004, 2006, 2006, 2007, 2008, 2009, 10, like that, and it goes on, and they combine together and a submitted charge sheet, charge is framed, combined together, that is not legal. It cannot be done. It cannot be done like that because it is not a continuing offense. There has to be a separate charge sheet. Now, what is the legal position? Let's discuss about criminal breach of trust first. Indian Penal Code Section 405. There is a legal terminology, entrustment. Now, what do we mean by entrustment? This is a very short word, but it has got very wide meaning. Entrustment is constituted by the facts alleged within the bounds of Section 405 IPC. Now there is another terminology, in any manner entrusted. It means interest arises whenever something, whether money or any other things, given to some person with direction as to how it should be dealt with. If the person paying intends to report trust in other expecting him to dispose of the money in a particular way, then only there is entrustment. Means, simple example I am giving. You have gone to a goldsmith. You have given him 1 lakh rupees to buy gold and make ornaments for my wife. You have placed the order for whatever ornaments are to be made. And if he is not doing that and he uses it for personal purpose, then it is a breach of criminal trust. Please remember, the mere payment by a debtor to a creditor is not entrustment. with specific direction. If you have given your money to somebody, then if there is a breach, then it is called criminal breach of trust. When can we say that there is a valid prosecution against the accused? Within the ambit of section 405 IPC. Well, my friends, I discussed first ingredients of entrustment, because that decides whether it is a valid prosecution against the accused or not. Charge is fine, but whether it is valid. Now discuss about ingredients of entrustment. Number one, in order to constitute entrustment, the complainant must be the owner of the property. Next, that there must be a transfer of possession. Next, that such transfer must be an actual transfer and not a fictional or notarial one. Next, that the transfer must be made to somebody who has no right excepting that of a custodian. Next, that such entrustment must be made to a person and not to a company or a firm. Last, the existence of malicia, that is guilty mind, must be proved. When these ingredients are satisfied, will constitute entrustment within the ambit of section 405 IPC, leading to a valid prosecution. If these conditions are fulfilled, then you can say that there is a valid prosecution against the accused. If not, then it can be acquitted. Now let us discuss criminal breach of trust by a public servant or by banker, merchant or agent, and that is IPC 409. This is very important for government servants, public servants, banker, merchant, agent, etc. Whoever being in any manner, I am reading out IPC 409, whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker, attorney or agent, commits criminal breach of trust in respect of that property shall be punished with imprisonment for life or with imprisonment for either description for a term which may extend to 10 years and shall also be liable to fine. This is a very serious offence. One has to be very careful in defense as well as in charge also. What should be proof of against accused? What proof is required against accused? Prosecution has to prove that accused, first of all, he is a public servant or a banker or agent, and he is entrusted with the property of which he is duty bound to account for, and that he committed breach of trust. This talks about falsification of accounts. IPC section 477A. Now in this there is another terminology, master and servant, that is fiduciary relationship. What is the meaning of it? IPC section 405 contemplates creation of relationship. Without existence of fiduciary relationship between the complainant and the accused, there cannot be any offence under section 409 IPC. IPC means Indian Penal Code. You are complaining. Who can be the complainant? If you have got fiduciary relationship with the accused, then only you can complain against him, otherwise not. The word trust is a comprehensive expression. The entrustment, E-N, trustment, T-R-U-S-T, meant M-E-N-T, T-R-U-S, trust what I have. The word trust is a comprehensive expression which has been used in section 409 IPC on covering not only relationship of a trustee and beneficiary, but also that of bailor and bailee, master and servant, pleasure and pledgee, guardian and ward, and all other relations which postulate fiduciary relationship between the complainant and accused. In this manner, you can make out who can complain against accused. In short, without existence of such a relationship, there can be no offence under Section 409 of Indian Penal Code. Now the question is, if trust is not created, suppose entrustment is not made, trust is not created, then what will happen? Can you make complaint against him? No, sir. Why? If the property is acquired by trick or by any other unlawful means, there is no entrustment. No entrustment. If it is acquired by trick or by unlawful means. If the acquirer of such property uses for his own use, he cannot be said to have committed criminal breach of trust, because in that case there is practically no trust created by the owner of the property. To win the case, the prosecution is bound to establish the entrustment, criminal breach of trust, and falsification of accounts by substantive evidence. It is a must for winning the case. Now, lastly, offence of cheating. IPC Indian Penal Code Section 420. Offence of cheating is established only when the following ingredients are present. When charge is framed, first of all, charge sheet is sent to the court, then charge is framed. Then in the charge, the following ingredients has to be there. If it is not there, then accused can be discharged or acquitted. Number one, that the representation made by the accused was false. Next, the accused knew that the representation was false at the very time when he made it. That he made the false representation with the dishonest intention of what? Of deceiving the person whom it was made. And the last, that the theory induced the person to deliver any property or to do something which would otherwise not have been done or omitted. Citation. There has to be dishonest intention from the very beginning, which is sine qua non to hold the accused guilty for commission of the said offence, that is IPC Section 420. Citation details. Joseph versus State of Gujarat. Year Act 2011 SC 2258. Alternate 2011 in bracket, then 7 SCC 59. GT 2011 in bracket 7 SC 53. You can refer the citations for this purpose. Legal point to be remembered. The offence of cheating under Section 420 IPC and the offence of criminal breach of trust under Section 409 IPC. I'll repeat because it is very important. Because normally my experiences as a trial advocate, charge is always framed under say 420, 409, 406 and all that. That is why this legal point is very important. The offence of cheating under Section 420 IPC and the offence of criminal breach of trust under Section 409 IPC, both these offences could not go together. They cannot coexist. Where a charge of criminal breach of trust is not proved, conviction under Section 477A, that is falsification of accounts, is not maintainable, not sustainable. Criminal breach of trust and falsification accounts are not of the same kind. There is an expression for same kind offences of the same kind. Refer CRP section 219 subsection 2. It reads, offences are of the same kind when they are punishable with the same amount of punishment under the same section. Then you can say that these are the offences of the same kind. Then trial will be conducted. Punishment can be given. Now when can you quash? Quashing under section 482 of CRPC for the charge of IP section 420. Essential ingredients. Intention or mens rea is the gist of offence to hold a person guilty of cheating at the time of making promise. As we have seen before this, it is necessary to show that person had fraudulent or dishonest intention at the time of making promise, or to show that he committed an act of cheating. Now, why we should go for quashing or discharge? Here is the reason. I am giving you a citation number also. Disputed grievances arise out of the agreement. It is a case of civil nature. No mens rea on the part of the accused, because grievance is created from agreement. So it is a civil matter. So charge sheet is liable to be quashed under section 482 CRPC. Citation number. First, 2006 CCR 20, Uttaranchal High Court, Sudhir Kumar versus State of Uttaranchal and others. I am sure you have enjoyed this video. I worked hard for this. I have taken keen interest in this. So please like it, share it, subscribe it. See you in the next video. Thank you very much.